representation, compensation, and other agency issues. In the preceding sections, we delved into various misconceptions within the real estate industry, such as the notion of mirror image offers. Now, we turn our attention to another long-standing myth, the threshold rule. This belief suggests that merely bringing a buyer across the property's threshold entitles an agent to a commission if that buyer ultimately makes a purchase. To gain clarity on this matter, it is essential to understand how an individual or entity becomes a client. What actions or statements from the buyer signify their status as your client? The term client is often misused in our industry. Is it possible to work with a potential buyer without officially considering them your client? Can someone be your client while simultaneously being a client of another licensee? If indeed the person is your client, does that automatically entitle you to a commission upon their purchase, or is it necessary to have brought them across the threshold? Addressing these questions is crucial to comprehend how we represent a buyer, the forms we use, and how our words and actions may impact that relationship. The answer is no. There must be a specific action or request for an individual to be considered your client. So, what are they before that happens? A prospect? A suspect? Someone you suspect is ready to buy, not someone being sought by the police? They could fall into any of these categories, but until they express or do something that establishes a client relationship, they are not your client. Therefore, in response to the earlier questions, yes, it is possible to work with someone who is not, or not yet, your client. For instance, if you casually meet them at an open house and decide to show them other properties, you should establish your agency relationship before proceeding. Failure to do so while showing them additional properties may imply agency, wherein your words and actions suggest representation without full disclosure or their election of such representation. And you could be wasting your time. Can an individual simultaneously be your client and the client of another licensee? Yes, it is possible. Establishing an agency relationship with a buyer does not nullify any existing agency relationship they may have formed. Therefore, it's conceivable that they could be clients of multiple licensees concurrently. I love the call you get from an investor asking you to send them properties. I always ask them, are you currently working with other agents? If the answer is yes, I tell them I am not interested. Upon establishing an agency relationship, are you entitled to a commission for any property meeting the threshold rule? No, you are not automatically entitled to a commission. The determination involves factors such as your employment relationship with the buyer, exclusive buyer, broker agreement, and evidence that you were the procuring cause of the closed transaction. So, what actions or statements by the buyer indicate them as your client? Contrary to a common misconception, having a buyer sign the READ form does not automatically make them your client. While it is related, it might not be true. The timing of when a licensee should have a potential buyer execute the READ form depends on various factors, as we'll explore in a typical scenario involving licensees and buyers. Imagine you are the listing agent at an open house. Before your arrival, you've gathered MLS printouts for flip properties. A buyer arrives, but are they your client at this point? No, they are not. Even when you engage in dialogue, show them around, and gather information, the client relationship has not yet been established. As the conversation progresses, the buyer expresses preferences, indicating potential interest in your services. Now, they could be considered your client. Instead of immediately proceeding to show a property, it is advisable to provide the READ form, explain representation options, and have the buyer make an informed election in writing. By having the buyer execute the READ form, you adhere to the Commissioner's Rule R4281101. F. Requiring prior written consent for dual agency. Even if the property to be shown is listed by another firm, obtaining prior written consent ensures compliance, establishing the client relationship. Showing houses over several weeks does not automatically entitle you to a commission. The concept of procuring cause comes into play, and simply having a buyer sign the read form does not guarantee commission entitlement. Procuring cause involves a nuanced consideration of various factors, and while there are no predetermined rules, specific issues must be examined before designating a licensee as the procuring cause in commission disputes between brokers. Arguments over procuring cause often arise when one real estate licensee believes they are entitled to a commission for a transaction, even though someone else drafted the contract and received compensation. According to Article 17 of the Code of Ethics among Realtors, disputes, often revolving around commissions, must be mediated or arbitrated. Such conflicts are typically brought to the attention of organizations like AAR or the local Association of Realtors. These cases undergo mediation with the aid of staff and realtor mediators, or they progress to a hearing where a panel of realtors decides the procuring cause and awards the commission to the deserving licensee. Another commission dispute arises when one licensee sells a listing from another licensee but receives compensation that deviates from the agreed-upon terms. For a dispute to be valid, there must first be a successfully closed transaction. The transaction must involve the appropriate parties, and a procuring cause dispute cannot be filed if, for example, the seller sells the property to another party. Additionally, the dispute must involve the correct parties. For instance, if a buyer works with a different agent to purchase a property, the procuring cause may be contested. In such cases, the licensee who steps in, writes the contract, and is compensated by the listing agent becomes the focus of the dispute. When filing a claim, it is crucial to target the broker agent who received payment for the transaction, excluding the listing broker unless they wrote the contract for the buyer. Two fundamental rules govern procuring cause disputes. 1. There are no predetermined rules regarding procuring cause. 2. Refer to Rule Number 1. Procuring cause awards rely on a preponderance of evidence, meaning they are based on the party presenting more evidence to support their case. The claimant, the party filing the case, typically believes they are owed the commission or a different amount than what was paid. The respondent is the party who received the disputed commission. To help present a case, certain questions may be considered. Which agent influenced the buyer's decision? Could the successful close occur without one of the agents? Which broker initiated events leading to the sale? Did the second agent address issues the first agent couldn't? While not strict rules, these questions serve as guidelines for determining the procuring cause. Several considerations are often deemed irrelevant, such as the length of the relationship with the buyer, the number of previous transactions, the duration of working with the buyer, and the licensee's professional tenure. Ultimately, procuring cause is solely determined by the facts surrounding the specific transaction, and prior relationships or the licensee's industry tenure do not influence the decision. Procuring cause and buyer agency. The scene. You meet buyer Betty at a party, and she tells you that she's getting ready to write an offer on a house she saw last weekend. You ask her if she's represented by an agent, and she says the only one she talked to was the listing agent. You tell her that it would be a good idea for her to be represented, and you offer to write the offer for her. Question: will you be guaranteed to be paid a commission? What was your answer? Did you think that establishing a buyer-agency relationship with buyer Betty would ensure that you'd get paid because of all the good representation you would give her by writing the contract and seeing her through the escrow? Or were you one of those who said you wouldn't get a commission from the seller as the procuring cause of the sale because you weren't responsible for Betty's choosing to write an offer on this property? This scenario is happening more and more these days. The issue is whether an agency relationship with Betty, in and of itself, would guarantee that you'd be determined to be the procuring cause of the sale of the property Betty mentioned at the party. There are many factors to be considered when the procuring cause of a sale is in dispute. One that should not be the sole determining factor is whether one of the disputing parties is the buyer's agent. Many other factors should be considered, such as who introduced the buyer to the property, who provided the details about the property to the buyer, which broker began a series of events that led to the sale without a break in continuity, Which broker could be left out of the transaction and have it still go together? Wouldn't all of the answers to these questions in the example above be the listing broker Betty had talked to before she met you? Hadn't Betty already decided to write an offer on that property before she met you? There is rarely just one factor that's the determining one in a procuring cause case. I think it's clear, based on the facts in the Betty scenario and absent any new developments, that the first broker, not you, would be the procuring cause of this sale. Representation and entitlement to compensation are separate issues. You say, how can that be? I would be the buyer's exclusive agent and I would write the contract. I would take care of Betty. Yes, you would take care of her, but in this scenario, you wouldn't be responsible for causing Betty to buy that property. She was ready to buy it when she met you. Now, if Betty wanted to pay you to represent her in this transaction, that's another matter. But that kind of arrangement still wouldn't make you the procuring cause of this sale and entitle you to be paid the cooperating commission from the listing broker. Note: the MLS rules state that the listing broker must pay the compensation offered in an MLS listing to the procuring cause of the sale. See NAR MLS Policy, Part 1, Section 1-2. If you want to be positively sure that you will receive a commission, get a BBEA signed by the buyer before writing any offer or showing any property.